All right. Hello, everyone. My name is Caleb Tingstad. I'm a lawyer at Beresford Booth here in Edmonds, Washington. My practice is one that is primarily transactional, although the litigation that I do normally involves what I refer to as business divorce litigation, litigation between shareholders and corporations, members and LLCs, partners and partnerships. And today I wanted to talk a little bit about records requests and how those can be useful tools in either LLC or corporate litigation, particularly when in the business divorce litigation context. And so today we're going to talk a little bit about what is a records request, what records shareholders and members are entitled to, and how records requests can have impacts on LLC and corporate litigation, and some issues that we frequently see when we're dealing with records requests, either responding to them on behalf of the company or preparing them on behalf of shareholders or members. Now, records requests are statutory in nature. Both Washington's LLC Act and Washington's Corporate Act give the beneficial owners of the entity, being shareholders in a corporation and members in an LLC, the right to request information from the company. The Corporate Act has a little bit more of a comprehensive step-by-step structure about records requests. There's actually an entire section, being 23B16, that is designated to do records requests for corporations, whereas LLCs just has one specific provision in the LLC Act. So it's important to remember here that these are statutory in nature. They also can be contractual in nature, either in a shareholder agreement or in an LLC agreement. The members or the shareholders can contract, and sometimes for corporations in the bylaws as well, can contract for additional obligations of the company in terms of records that the company is required to keep. But the primary basis, the baseline level, is statutory in nature. And what you'll find in both the Corporate and the LLC Act is that there are baseline requirements that the corporation basically cannot fall below in terms of the records that it's required to keep on behalf of either the shareholders or the members, as the case may be. Now, normally records that either corporations or LLCs must keep include the governing documents. So for LLCs, we think of the certificate of formation or the LLC agreement, and for corporations, we think of the articles of incorporation or shareholder agreements. There also must be the corporation or the LLC must keep a list of its beneficial owners, either the shareholders or the members. And that sometimes becomes really significant when you're dealing with a company that might have a lot of beneficial owners. Maybe it's a company that's been around for a long time, and not all the beneficial owners know who they are because there have been significant history of transfers, either of the stock or the LLC interest. And also this concept of what the LLC Act calls accounting records, and the Corporate Act just outright refers to as financial statements. And a lot of times it's difficult to identify what is considered either accounting records or financial statements. When we put together records requests, we are normally asking for a balance sheet, a cash flow statement, those types of things. But the statute generally leaves those terms undefined. And now we get into why records requests can be useful. So when either companies or the company's beneficial owners get into litigation, there is almost always discovery that is exchanged, and those are court-ordered obligations of the parties to exchange documents that could be relevant to the case at hand. Records requests are useful because they impose mandatory requirements on the companies at issue outside of litigation. And you'll find that the statute that provide the baseline for records requests are mandatory in nature, and actually in some cases can provide for potential fee shifting, where if the company fails to comply with the records request without a valid reason, then the beneficial owner would have a cause of action against the company to institute an action, perhaps for an injunction requiring the company to disclose the information that the beneficial owner is seeking. And one thing that we frequently find is courts have little tolerance for those types of actions. Really is a clog on the court's docket, because it has nothing to do with any merits of any actual dispute. These are records that the beneficial owners are absolutely entitled to under the statute, and courts are, I would say, are more willing to shift fees to the company to reimburse the beneficial owner for their attorney's fees when a corporation or an LLC does not have good grounds for denying the request. It also allows beneficial owners, being the shareholders and the members, to obtain really vital information that could be useful as the dispute proceeds. And so many times at the outset of representation, the lawyers are trying to get their hands around all of the information that's going to be at issue in the dispute, and going and getting it from the source can be a helpful way to start the process, to make sure that everyone is basically operating under the same set of facts. You know, what shareholder agreement are we under? What LLC agreement are we under? What are the provisions of each of those? Who are all the characters and the players that are going to be involved in the dispute? Those oftentimes become very significant things. Now, there are a couple of things in records requests that pop out as potential issues that we frequently see. Most frequently is just the proper notice and the proper recipient are not identified in the request. There was a recent case that I actually wrote a blog post on earlier this year that talks about how a company, it be either a corporation or an LLC, has a right to deny a records request if it's improperly provided to either the wrong party or is not sent to the proper address. And the statute is very strict, and oftentimes either the bylaws of a corporation or an LLC's operating agreement will be very strict as to who these types of notices need to be given, and how much notice and prior advance notice also needs to be given. Also, for some records, specifically in the LLC Act, there must be a purpose that's provided. And sometimes when for individuals who are not parsing through the statute in advance of providing the records request, the purpose may be neglected or may not be properly explained. And so for practitioners who are preparing the records request, you need to be thoughtful about the purpose of the records request. There is some case law, particularly out of Delaware, that is helpful. Because Delaware has, particularly in its LLC Act, has very similar language to Washington's Act, and there's some very helpful Delaware case law that explains what are proper purposes when parties are sending over records requests. And that includes today's presentation. If anyone has any questions, my contact information is here. Once again, thank you all for either watching or attending. And like I said, if you guys have any questions, you can reach out to me. Thank you.